Keeping your business healthy in today's marketplace can be a challenging and overwhelming task. From the threat of litigation inside and outside your organization and the inefficiencies that can rob your bottom line as a result of unproven marketing programs, the deck can be stacked against you. To get ahead of these challenges and stay ahead of your competition, the Bottled Business Sense Show provides practical business solutions that uniquely emphasize key legal principles, management techniques, and marketing strategies to protect and ensure the longevity of your business. You'll learn how to implement marketing and protection principles equal to those used by today's most successful corporations. Join your host, Bill Bernard, Rick Moscoso, and Steve Smith for some high-energy discussion that will inspire you to take control of your business so it can prosper in today's consistently challenging business environment.
Welcome to the Bottled Business Sense Show. My name is Steve Smith. I'm one of the hosts today, and I want to welcome you to our weekly show. As you guys know, I just recently joined the program, and I'm really happy to be here because these two guys they finally got this program dialed in, and some great information is usually received from every show we do. This week, we're going to be turning to our legal expert, Bill Bernard, who's going to lead us through a discussion on some of the legitimate safeguards that you can expect from being an employer and an employee. So he's going to basically talk about the things that employers and employees need to know in order to work effectively in the workplace, reduce litigation, reduce any kind of legal stuff that tends to get in the way and cause businesses to get off track. So Bill, welcome to the show this morning. How have you been?
I'm just doing great, Steve. In the midst of a trial, we're dark for a day and a half here, and so I'm taking the opportunity to catch up on my rest a little bit and to enjoy the show. So I'm moving forward and hoping good things to come toward the end of the year. And can you believe it is already the end of August? The summer's gone. Isn't that unbelievable? I
know. It does. It flies. You know, it never used to fly like this when I was a kid, but it flies now.
And we have on the other end our longtime co-host Rick Moscoso, who's been involved in a lot of things recently. How you doing there, Rick?
Yeah, I'm doing great. A little different opening today with Steve opening the show, but it's a refreshing change, and hopefully everyone will enjoy the new format that we have going on here at the Bottled Business Sense Show.
I think so too.
Now, for those of you that may be tuning in and watching this show for the very first time, not only is Bill our resident legal expert, and he finds time to be on these shows when he's not in court, but Rick is also our video marketing expert. In fact, we just had a show recently that talked about what do you do with your videos after you've cut them, after you've produced them, where do you go with them, how do you market them effectively. So, Rick, I know that was a great show, and I really appreciate you kind of putting all of your secrets and your tips into your game plan so everybody could learn from that. We broadcast every week, Tuesday morning at 10 o'clock. So if you like what you see, tell your friends. Have them show up to the Bottled Business Sense show. We also simulcast on Blog Talk Radio. So if you're not in a position to watch, you can certainly listen and get the same great benefit. So let's kick off with the show today. So Bill, why don't you set this up for us? Because I know for business owners who have employees, especially in the lovely litigious state of California, this is a hotbed. I mean, this is a place where a lot of times you can step in it without even realizing you're stepping in it. So give us a sense of what you're going to talk to us about today.
Well, what we're going to focus on today, Steve, and thank you, is really how to keep the workplace prosperous and moving along without the burden, as you said, of potential litigation, but also to create a situation where there's not as much employee turnover. As you know, when our entrepreneurs out there and sole practitioners, as I like to call them sometimes, as they get bigger and grow, they tend to take on employees from time to time, and in order to make that process profitable, and thus the business profitable, you want to make sure you have an environment where everybody gets along and, more importantly, understands each other's obligations once they become a family, if you will. And so,
okay, so let's set this up a minute so that whether you're an employee of a company or you're running the company, you kind of know what to expect, what to get out of this conversation.
Exactly.
So I'm a business owner. I've got certain obligations towards my employees. based on the fact that I'm running the business, and the state of California and probably other states that, from people that are listening to this, have regulations that determine how I must purport myself, what kind of workplace I must oversee. So I've got those obligations. Now, an employee, as you said, has expectations about what they're walking into when they go to work for a company. Mm-hmm. But I would imagine they've also got obligations too in terms of how they act, what they can do and what they can't do, what their rights are and things like that. So which side are you going to start with first?
I think I'd start with the employer obligation side, Steve, because you can read into that or extrapolate from that a lot of what you would expect from your employees once the employer, who usually takes the rowing oar, provides a guiding light, if you will, to the employees, because typically what happens in these situations, an employee handbook is given, should be given to an employee, and that spells out a lot of the rights and obligations of both parties, and it's typically a place you would go to really get a good insight as to what each other has to do on the job.
Okay, so I hear a lot about employee handbooks, and I hear a lot of that from people that are in the human resource business. You obviously deal with it more from a legal compliance standpoint. Businesses that are a certain size have to have employee handbooks. So when you work with a company and there isn't an employee handbook, and that's an established company, they're not starting from square one, they're already up and running, what are some of the reasons why you find that people haven't already done that?
Well, that's an excellent question, and there's a couple of reasons why they don't typically do it. One, they don't think they have to. You just mentioned that a company of a certain size should have one. That's actually not totally correct. Any company, anybody who has any employees, I would say, of any kind, whether it's 5 or 50, should have some direction in writing that protects them from what's going to happen once that relationship progresses. So yes, they typically just don't do it either because they don't think they have to, or candidly, Steve, they don't want to go to the expense of paying an attorney the money that it might take to make one, because typically a really good one could be anywhere between 30 to 40 pages long.
So, Bill, would you say then that let's say you're a sole prop, but you do have contractors or for projects that you do. Let's take my video marketing business, for example, and I have a vendor come in that helps support a project. Are these similar safeguards in that situation, or are they totally different?
Well, they're different and similar, Rick. What I mean by that is they're different because that's not an employer-employee relationship, but they're similar because you can then create a separate contractual relationship between that vendor or independent contractor, if you will, and yourself as the business owner in order to protect each other's interests.
Okay, Bill, so let's get into a little bit of the weeds on the employee handbook, because I think that's a good place to start. From the owner or the business owner side of the fence, what 3 things does that employee handbook have to have in it that a business owner may not be thinking about but is fundamental to their own protection?
Well, that's a great question, but also a tough one, Steve, because a lot of clients ask that too, but in an effort to keep the employee handbook down to a minimum, I would contend that there are just probably 10 or 15 things really that you have to have in it. But if I had to narrow it down to what I would consider to be the absolute extreme important ones, one would be the workplace environment and the practices concerning the prohibitions against age, race, sex discrimination, sexual harassment, different types of responsibilities that the employer and, interestingly enough, the employee has to make sure that that kind of an atmosphere doesn't exist within the workplace. Very, very important. Another one would be the requirements by Cal OSHA, the safety standards that must be in place in a business to make sure employees aren't injured on the job. Very, very important. And, of course, a third one would probably be the pay requirements and notice requirements when somebody is being paid on a job, working overtime, or eventually decides to give notice and quit. Those things should be pretty well laid out so an employee knows what he has to do and an employer knows what he must do to make sure that that relationship is smooth.
All right, so let's say the employer has his handbook. He's come to you and you've met with him and you've sat down and crafted a handbook for his business.
Mm-hmm.
How reliant should that owner be on that handbook in the course of running his business? I mean, I can just see it now. It's probably akin to writing a business plan. Most people that spend money to have other people write their business plans, once they've gone to the bank and secured a loan, it goes on the shelf someplace and they never open it up again. So when it comes to an employer having a handbook to control and govern what goes on in the workplace, how should they be using it once it's written and distributed?
Well, they should be using it verbatim almost, Steve. In other words, I think what your question is implying, and you're absolutely correct, is that it's not worth it's not worth the paper it's written on if it's not put in use. And that's typically why, as businesses grow, they have an HR department or a human resources department put in place, because then they take over the burden of ensuring that these policies, and that's in fact what they become company policy, that these policies are followed and put in place, because that takes the burden off the actual owner and the entrepreneur to focus better on what he does best, he or she. So for a small business owner, it's often a very big burden, because if they don't have an HR department, they're taking on all of this at once in much a similar way that you and I remember once had a discussion about how when you become a business owner after working for somebody else for a long time, you now have to not only practice your trade, but you have to learn how to market your own business. And that's becoming a businessman and a professional at whatever you do. So it puts a burden on a small guy who doesn't have an HR department, for sure.
But at the same time, though, Bill, it protects him from any eventualities that are out there, because I think we spoke about this on a show several months ago, where you talked about an employee handbook, and as an employee coming into that, a new employee coming into that business, it would make sense as an employer to have those safeguards built in where they acknowledge and have read through that employee handbook, so they know exactly what the expectations of both sides are.
That's right, Rick, and that's an excellent point. Typically when I do mine, at the end of the handbook, in addition to the handbook itself, I have usually a one-page acknowledgement that's signed by the employee, and this is a perfect example of what Steve asked earlier about the interplay between the two. The employee acknowledges, it's his obligation to acknowledge that he has read what's contained in there and that he knows what he's supposed to do. It's the employer's obligation to give him that, to make sure he has access to the handbook and that he knows what he's able to do, what he must do, and more importantly also what he can do should his rights be trampled upon. So by that signature of the employee, it creates a dual role of notice to both the employee and the employer, and it's a really great way to protect yourself. You guys know I'm really into paper. I guess most lawyers are, but you have to have things in writing if they're going to have any lasting effect.
Well, look, I can get into the idea that things in writing are taken more seriously. They establish a benchmark for how you're going to perform, because if it's important enough to put it in writing, then it's there for everybody to see. But I'm also thinking, you're in the middle of running a business. You might have 10 or 15 or 20 or more people doing a variety of different things in the facility that you're in. How much daily play does an employee handbook get when you get into situations where you're having to settle conflict, or you're having to have sensitive meetings with an employee that maybe not living up to what they're supposed to be doing? I mean, there's all kind of reasons why somebody might have to come to somebody else and say, we have an issue that we need to talk about. So in those situations, how frequently does somebody reach out for the handbook and say, gee, let's see what the rules say?
Well, Steve, if you're serious about this stuff, again, let's assume, I'll assume by your question we don't have an HR person, because that would exactly be the job of the HR. Before that person comes in and meets with the HR representative, that HR knows the employee handbook inside and out. There is no need to refer to it specifically. However, it is like a dictionary or an encyclopedia, and if it's needed to be referred to, it's just pulled off the shelf, much like one of my law code books are pulled off the shelf whenever I need to check a code section. I generally know what the code says, but if I need to be specific, I can go right to it. That's how the handbook should be typically used. An employer has the obligation to make sure he's familiar with that, or if he or she has an HR person, they have the obligation to be totally familiar with it, and then they use it as a reference guide, more or less, as opposed to having to pull it off and read verbatim every little situation.
Okay, so now let me ask you this. You've got your handbook, it's been distributed, all of the employees have acknowledged that they've received it, hopefully they've read it, so now you're going on with business as usual.
Mm-hmm.
What things should an employer not be expected to rely on the employee handbook for? Because I can see how in some cases you can almost use it as a crutch situation for any absence of making a good decision about what's happening, in the moment. So can you think of any situations where an employer should not rely on the handbook to do something that maybe they should be doing?
Sure. A couple of good examples, actually. And by the way, what I'm about to tell you many times isn't in a handbook, and that goes directly to your question, Steve, but it could be placed in a handbook if indeed you wanted it to. Let's take a couple of good examples. Making verbal threats to other employees, even if it's just in a joking manner. Most times things that minutely will not necessarily be reduced to writing, but it could be made a company policy. You would expect an employee that you hire to have the common sense not to do that. Behavior that might lead to some sort of conflict where there's verbal abuse in the workplace that doesn't necessarily arise to the level of discrimination. You don't want your employees bullying other employees. There's no workplace law, by the way, against bullying. The object there is to either leave your job and get a new job, or report it to HR and try to say that it's affecting your health or some other facet of your life that's going to affect your ability to do your job. But at that point, it's not really a violation of law. So those kinds of things, menacing gestures or some sort of verbal language that doesn't rise to the significance of a real lawsuit, common sense actions, not making nasty jokes around the workplace, things of that nature. You'd expect an employee to behave appropriately and act accordingly. And some of that stuff, can be covered either by an overall general type of policy, or just called in and the employee having a talking to and saying, listen, you don't have to have something in an employee handbook, by the way, to fire an employee. If you're an at-will employee and you have no claim that violates public policy or some type of law within this state, you can be fired at any time for any reason by your employer. So you're going to have to learn to behave yourself and make sure that you act like a normal guy or a normal gal.
All right, let's move away from the handbook for a moment and get into some real-life work interplay between the boss or maybe a facility supervisor that's acting on behalf of the boss, and just the general staff that's there. In your experience, what have you found to be some of the common situations that arise for which there might be a conflict between employee and the boss, the owner, that just go beyond having a conversation in the office and then it's over and done and everybody's happy? When this thing rises to a dispute that can look like it might take some time, it might lead to some some lawsuits, some litigation, some other nasty stuff. Are there things that you've worked with companies that you can kind of point out that when this starts to happen, this is something you don't want to have happen?
Well, no question, Steve. And of course, the ones that typically come to mind is some sort of behavior that could lead to some discrimination claim, whether it's by ancestry, medical condition, sexual orientation, marital status, nationality, sex, religion, you name it. It could. When you start engaging in that type of conduct, The law in California measures that by both an objective and a subjective standard. In other words, would a reasonable person in that class, whether it be marital status, race, age, we call those classes, would a reasonable person in that class be offended by the content? That's number one. Number two is the subjective standard. The person who is offended has to subjectively actually be offended. And number three, it has to be pervasive and severe conduct. It can't be just a one or two time thing. If those things are occurring and an employer knows an employee or a supervisor of the employer is doing that kind of stuff and he does nothing about it, then the company can be held liable for that as well as the supervisor personally, and that gets very hairy. And those kinds of things happen when you're a third party. You may be a third party. Rick may be witnessing this conduct and report it, and now he's fired for reporting it even though he's not involved in it. He's reporting a violation of law, and that's called retaliation. He could then sue for retaliatory conduct for being terminated for reporting a violation. So those are the big instances and the most severe instances that carry with them the really critical high damages.
So what happens if that situation and a third party observes somebody not bullying but saying something disparaging about another person, but they're actually not offended by that situation, but the third party reads it all the wrong way and reports?
Well, if the third party reports it, Rick, there's two issues there. Number one, you have to use the objective and subjective standard I just mentioned to actually find out if there is a violation against the party who the conduct is being directed toward. But the retaliatory conduct could only go against you, and that would only be if there is a potential violation and then you report it and you're terminated for it. It doesn't matter what your personal perceptions are. It matters that you reported something that actually is a potential violation, and for that reason and that reason alone, you were terminated. Now remember how critical this is, because if you're an at-will employee, if you don't have a contract for any specific period of time that you're going to work for somebody, if you don't have an implied in fact contract where you've been working at some place so long and you have a good track record that it implies you can only be fired for reasonable cause, that means you're an at-will employee. And if you're an at-will employee, you still cannot be terminated at any time for any reason, like you typically would be able to be, if you are complaining about a violation of public policy, and that certainly would include reporting to HR or to the boss that there's sex discrimination or harassment or some sort of discrimination going on in the workplace.
All right, so Bill, let's bring in a real life scenario that I'm sure a lot of people watching or listening to this program can identify with.
Sure.
You're working for a small company. Maybe there's only 8 or 10 people involved. You know, when you consider the owner of the company, you have these kinds of harassment in the workplace, something that you just can't live with. That it's really affecting your work. Now the company is either not big enough or chose not to have somebody in an HR role on site. Maybe they don't even have one of these third-party companies that act as an HR facility for that company. And you're a little tenuous about bringing this to the boss because you're afraid that it may blow back on you.
Right.
As an employee, where do you go with that?
Well, as an employee, you have a couple of different choices. One is you decide to ignore it, or you do report it to the boss. I mean, you could go to a public agency and report it, but that's going to just cause the agency, like the EEOC or the DFEH, Department of Fair Employment and Housing, or the Equal Opportunity Employment Commission, they're going to come back and investigate it with the boss anyway, so the boss is going to find out. So really you have two choices, Steve. You ignore it, or you do something about it and realize that if you get fired because of it, you're going to get a lawyer and bring a lawsuit against your employer. It's really that basic and that straightforward. But
well, all right. So look, that may be basic, but if you put yourself in the shoes of an employee who has a job, maybe it's not their ideal job. It's not one that they've wanted all their life. They're doing it because they need to earn money. They've got a family at home. Losing that job could be perilous, for them supporting their family. And they're just trying to do a good job. They really don't want to be involved in a bunch of stuff. And they're looking at two scenarios. Either I continue to just deal with this unfavorable environment and the stress builds and I lose sleep and other stuff happens to me personally, or I report it to the boss and I find out later that the boss doesn't favor my side, and so he thinks I'm a troublemaker and he fires me, and then so I mean, can you kind of step away from the black and white of the law and appreciate that many employees that get in situations like this just don't see a way out?
Oh, I could certainly appreciate all of that, but I think that's a little different than coming to the conclusion that there may not be an easy way out. You have two choices. Actually, I call it 2.5 choices. Here's what I mean by that. Any good employment lawyer will tell you, without question, that before you go and make any formal complaint, you go to the employee who is giving you the problem and you tell them in a very nice way you don't appreciate it. Please stop. Every major organization that I know of involved in the law in this area recommends that conversation take place. And that you document the conversation and make sure you know what time, what day you spoke to Joe Blow, and here's what you said to him. And then if that doesn't resolve it, then you've got the only two choices left. Either you say I'm leaving, or you report it to the boss. Because remember, you're dealing with a bigger picture here. You're dealing with someone who's probably going to do this to somebody else. So you're just not protecting your own interests. You're really squealing, if you will, to protect the rights of a lot of different people who are probably being abused or going to be abused by this kind of an individual.
All right, so I guess the insight to this part of the conversation is when you go to work for a company, there are some responsibilities you have to take on as an employee. You can't just operate in a vacuum, show up, do your work, leave, and expect that you will never have to deal with anything uncomfortable, whether it affects you directly or it impacts the workplace that you're operating in. So you just have to know that. You've got to be able to recognize that in order to work effectively in a workplace as an employee, sure. There's not only rights, but there's obligations, and you can't walk away from them.
Sure, and let me give you one that's not so serious, Steve. Employees who are discharged must be paid by their employer all wages due at the time of their termination. Wages include unused vacation, but it doesn't require any unused sick leave. So the boss is obligated to pay you all your wages and your vacation pay, but not necessarily any accrued sick leave. If you're an employee who gives at least 72 hours notice to your boss, you must be paid at the time you quit, that moment. And many times labor board claims are brought because employees, those rights are abused by the employer. And I mean, that's a classic example of an employee knowing what his obligations are solely with regard to himself and not having to worry about the atmosphere or what's going on in the workplace. Now he's
right.
leaving a job, and there are certain obligations. There's also a lot of other things I could get into if we had the time, and that would be overtime obligations and when you're paid and how you're paid for working a certain amount of hours over and above 40 hours a week and that sort of stuff. So there's a lot involved here, and that's why I say these handbooks, and this show really wasn't meant to be about a handbook per se, but rather an understanding between employer and employee. I bring out a handbook as a good example because basically most of what you need to know as either an employee or an employer is contained in there, and a good one prepared by a lawyer that knows what he's doing. So it makes things easy for everybody. And bingo, what do we want to do on this show, Steve? We want to make a person's business prosper, right? It's certainly going to prosper a lot better in a conducive atmosphere that's harmonious as opposed to one that's having some issues.
Well, great. Rick, any final thoughts before we wrap up the show?
No, this has been a great review. Like I said, we went into this a little bit more in detail several months ago, and so it's good to a refresher from my perspective to get back into this. So I don't have any additional questions. I mean, we could go on and on and on and throw different scenarios at Bill, But
I like doing that.
Yeah. But I don't think we have the time here in the short time that we have. So
No, it's a lot easier just to get me to do a handbook for you. That's right.
Yes. So wrapping up the show here, folks. If you've been listening to this and you're either an employer, an owner, or an employee, you've got some things to think about. Mainly, just Bill, if I can just kind of wrap up the final point here. There's expectations and there's obligations on both sides. You should know what they are so that you can contribute to making the workplace a productive, fun place to be as opposed to a litigious place to be. And certainly if you're a business owner and you don't have a handbook and you're really not up on this stuff, reach out to Bill. Bill and I have done business together for a long time. I've sent him to some of my clients. He's excellent at what he does, and he can tell you fairly quickly where you're missing and possibly being exposed because you're not covering your bases. So make sure you reach out to him if you need that kind of service.
And I would just end. I appreciate that, Steve. I would just end my portion of the show on this note, and that is, think about it from this perspective. Where do we truly spend, even though we're married and have families, where do we spend the bulk of our time? We spend it at our place of employment or in our business, right? And it would be silly, wouldn't it, to not want that to be a place that you look forward to coming to as opposed to the opposite?
Absolutely. Okay, folks, this ends the Bottle Business Sense show for this week. We appreciate you watching or listening. Go to our website at www.bottlebusinesssenseshow.com. You can see all the other shows that we've run. We kind of archive them so you can go through it and pick and choose based on what you're interested in. But tune in for more shows that we'll be announcing sooner, and we're always looking for great topics. So if you've got a particular topic that you're interested in, get on one of our sites where you've got some places to put comments and let us know. We'd be more than happy to consider those topics for future broadcasts. Bill, Rick, thanks for being good contributors, good engagers on the show today, and I look forward to handing the microphone off to one of you guys next week.
I know the feeling, Steve. I'll look forward to our next show as well, and wish our viewers and listeners a very prosperous week ahead.
All right, and have a great week, everyone. We'll see you next week.